Whereas Olevec addressed when a court should suppress compelled breath test results, Elliott considered when a defendant's refusal to submit to such a test should be suppressed. See Olevec and Elliott. Declining the state's invitation to overrule Olevec, we reaffirmed Olevec's holding that paragraph 16 affords a defendant a right not to be compelled to submit to a state-administered breath test and a right to refuse such a test. See Elliott. We then reviewed the relevant history and case law leading up to and immediately following adoption of the self-incrimination provision in the 1877 Georgia Constitution to determine what consequences flowed from a defendant's assertion of the right to refuse breath testing. See, they went all the way back to the 1877 Georgia State Constitution. And you can do that too. If you know what you're doing, you can go all the way back to when the Constitution was first drafted in Georgia. Based on the historical record and decisional law, we concluded that the self-incrimination provision adopted in 1877 prohibited admission of a defendant's refusal to speak or act as evidence against him, and that no subsequent developments altered the meaning of the self-incrimination provision that had been incorporated without material change into paragraph 16 of the 1983 Constitution. So the only way it could have gotten changed was when they adopted the new Constitution 1983. Nothing was changed in there, so they couldn't do anything about it. Accordingly, we held that paragraph 16 precludes admission of evidence that a suspect refused to consent to a breath test. The state has the burden of proving that evidence challenged in a motion to suppress is admissible. See Kennebrew v. State, and that was a 2018 case, holding that on a motion to suppress evidence obtained from a warrantless search, the state has the burden of showing that an exception to the warrant requirement applies. See State v. Hilton, and that's a 2020 case, noting that on a motion to suppress a custodial statement, the state bears the burden of establishing by a preponderance of the evidence that a defendant's custodial statement was voluntary. And that's what I'm talking about. You have the right to remain silent. You have to tell them, here's what you do. They stop you, you give them your driver's license, your registration, and your insurance if they ask for it. And then they start asking you questions like, have you been drinking? I don't answer questions. I'm exercising my right to remain silent. Anything after that, they cannot ask you. Once you exercise your right to remain silent, they can't ask you any more questions. Otherwise, it's a violation of your rights. If you answer, it's a violation of your rights because they continued asking you questions, which they're going to. Now, the other thing is,